He represented himself during his trial. Well, yesterday, Waukesha County received Brooks's handwritten letter. Brooks says he wants an attorney to possibly appeal his conviction. A year after causing mayhem and bloodshed at Waukesha's Christmas parade, Darrell Brooks sent this letter notifying the court of his intent to seek post-conviction relief. Requests, quote, the assistance of counsel from the public defender's office.
As I think he saw how well he did or maybe didn't do at trial and realized maybe he's not his best advocate.
Brooks continues, quote, there are clear issues of the law and legal facts in his case. Kim says it will take a public defender at least 6 months to review all of Brooks's paperwork.
The appellate attorney is going to have to literally reread every word that was uttered during all these proceedings and try and figure out whether there were any mistakes that were made along the way.
Kim says the trial judge will have the opportunity to rule on post-conviction relief first before an appeals court takes the case. But even if Brooks is denied at the appeals court level, Kim says the process is far from over.
This could theoretically be continuing for years and years before it's finally resolved to a point where the sentence is set.
Correctional institution in Waupun, that's where all prisoners start out. Kim says it's possible Brooks could spend weeks or months there before transferring to another state prison.
Case number 21 CF 1848. May I have the appearances, please? Teresa, can you get the starting with the state notification on? Go ahead.
Good afternoon, Judge. Sue Apper appearing for the state. Thank you for allowing me to appear by Zoom. I'm sorry I'm not present in person.
All right, then. You're welcome for allowing me to appear by Zoom, and I certainly understand this was set quickly. Your appearance, sir, please.
Here is a third-party intervener in this matter under special appearance. Not sure what this court date is about, but as you can see, I'm not allowed to have any legal paperwork at this time. I was placed on the protocol, a suicide watch protocol, without even being suicidal. Still would like the rendering of the accounts in this matter, if I may.
Mr. Brooks, the court set this because you had filed one document on the 15th that I construed as a motion for a stay pending appeal. And you may or may not recall, but when the state asked me to consider that at the conclusion of Wednesday's hearing, I indicated I would wait until all of the judgment of convictions had been signed and then schedule a hearing. I have signed the judgments of conviction, and because of some of the procedural, if you want to call it that, things that have happened. I know you were taken to Milwaukee for what was supposed to be a jury status hearing on 2 matters. I thought they would keep you there, but it's my understanding all of those dates were adjourned, and so you were brought back to the Waukesha County Jail. And so since you were going to be here, I thought I would schedule this for that motion hearing in order to address that. I can see very plainly you don't have any of the documentation. In an effort to be fully transparent with you, that one piece of paper apparently did not get scanned into the electronic file, and we're having some trouble finding the paper copy at the moment. And so I don't even have it in front of me. Clearly, you don't have it in front of me. I believe we gave you a copy of you gave us 3 inmate communication forms together. Do you remember that on the 15th?
I don't recall giving any ICFs. I recall submitting the notice of right to appeal.
So I recall it being 3 inmate communication forms, but I thought they were brought into court. I could be mistaken on that. That was my recollection. One, at least it was received by us on the 15th. One requested a certified copy of the record and waiving fees. Another, and that one was dated the 13th. Another it said the 4th, but I believe it was from the 14th, talking about waiving costs and fees.
Oh, I recall. I didn't mean to interrupt. I recall that was the week before last when I submitted that one that you just referred to.
Okay, and then there was the 3rd piece of paper, and I know the state had asked for a copy of it. When I had referenced there were some filings, my clerk is telling me she recalls the last one being on a plain sheet of paper that you brought with you into court. It was copied for all the parties, and unfortunately we're having a hard time finding it at the moment. It's not scanned into the file. They do a large auditing process. It hasn't been picked up yet. We feel it's around. We just need to file it or find it. So if need be, I can simply reschedule this for a time when you have it in front of you, when the state has it, and when I have it in front. But that was my hope to address it today. If you wanted to address it orally, I could do that as well.
No, I would rather all the paperwork was all in my legal work, which obviously right now I'm not allowed to have. So
that would still be in your cell.
I'm not allowed to have anything in my cell. No paperwork, no mail, no hygiene, anything.
Do you believe if given access to it, you would be able to identify and find the one piece of paper that I'm talking about?
Was that the actual motion?
I believe it was a motion for stay pending appeal.
Yeah, I'm sure. If I don't see the thing, just so the court is aware, Your Honor, when they strip your cell, because I had so much legal work, they kind of just put them in like boxes. And I'm not sure where they take them. I don't know if they take them to property, or I don't know if they keep them close. That part I don't know, but they kind of just put everything together. So I would need some time to actually shift through to see what's in the place. If that helps.
I totally understand. I'll be in communication with the jail, access to the legal documents that were taken from your cell so that you can locate this form and have it refiled with the court in the event we're not able to find it. I apologize for that. If you were to see everything that I normally have up here, and certainly at the conclusion of a month-long trial, I have a lot of paperwork.
Yes.
I'm still looking through my notes. I haven't found it yet. Again, I think it's just because we're under the gun to find it. We're not finding it. And what I'll do is I will just simply reschedule this. What it may mean, though, is it will be after you are transferred to Dodge, and then I'll have you appear by video for that.
I do. I actually, as soon as, obviously all this took place, as soon as I walked out of court, I went right into this. I had been asking them for the last 2 days about the legal work, because I knew this was going to come up at some point. And I'm like, can I at least just have access to my legal paperwork? I'm not asking for anything else, just that part of it. And it's kind of just like the whole runaround thing. Like, I don't know if
I will be in communication with them. I obviously don't know all of their procedures and protocols, and I want to be mindful. If they've put you on a suicide watch, they do that for a reason, but if need be, I will require them to give you access so we can find this piece of paper and have it refiled with the court. And then once that happens, I'll schedule it for a hearing, but it won't be next week. It might not be till the week after, just because of some time that I have off and needing to make sure everyone has copies of it.
Just so that the record's clear too, Your Honor. They said this was procedural protocol. It wasn't because I demonstrated any suicidal behaviors or even said it. I was told it was just protocol. So it wasn't because I said anything or exhibited any behaviors that would make them think I was suicidal in any way. I was told it was just protocol.
Understood. The court provided you with the written explanation of life sentence, written explanation of determinate sentence, and then the notice of right to seek post-conviction relief. And actually you acknowledged that, you indicated you plan to seek post-conviction relief, you dated it, and that is on file. I'm sure what we will do is forward that to the public defender's office. That's typical when there's been a conviction and someone's in custody, to see if you qualify, which presumably you would, for public defender representation. What you do with that is up to you, but that's typically the process you've, and I'm sure they'll be in touch with you about that.
Will I be able to have access to the paperwork that you just referred to, that not the appeal part, but the other paperwork that you referred to?
The motion that you filed?
No, the something you said you provided.
The written explanation of.
Yeah, all that paperwork. Would I be able to have access to that? Because obviously, when it was given, was right after everything had wrapped up Wednesday, and as soon as I walked out, they took all that. So
I'll indicate to the jail administrator that it's 20 pages in total. It's at least labeled in our file as written explanation of determinate sentence, but there's 20 pages because of the number of counts involved. That and the motion for stay pending appeal, however it's phrased, will be provided to you. And if you even want the copy of the notice of right to seek post-conviction relief, you should have received a copy back, but I'll indicate that should be provided to you as well. Okay?
And actually, Judge, I think if we're going to reschedule this at a time when he's in the prison, we may encounter the same problem, that he may not get immediate access to his paperwork, so we may want to take that into account when we schedule.
Okay.
Attorney Opera is right about that. From my understanding, I was told you have to go through an intake process when you don't have access to certain things. I guess I won't know for sure until I'm actually there. But to my understanding, that is the process.
Why don't I do this? Once we get the paperwork that we need that's in your property inventory, presuming that's where it is, and I'm able to set the motion, I'll make sure that when we send a notice of hearing, that all of these documents I've just talked about are copied and sent with it. It would be my hope and expectation that might get to you because it's being sent from the court. And then we'll go from there.
And if I'm not in possession of anything, should I just let you know that if it's anything that I may be missing at the time of the hearing? Would it be okay to let you know what I have and don't have?
I think that would be fair. Yes.
Thank you, Your Honor.
As you consider the issue, which is a motion for stay pending appeal, I would direct your attention to Wisconsin State Statute 808.07. And there's case law that supports that, but it's the factors the court must consider for a motion for stay pending appeal. 808.07.
808.07.
Yes.
Would I be able to look that up, considering that
I'll make sure.
right now?
I'll include that in the cover letter.
Should we send him the pro se manual on appeals?
Do you want the pro se manual on appeals?
Yes.
We'll send you that too.
Thank you.
You're welcome. All right. Attorney Opera, then anything else? Are you satisfied with the procedure I've outlined here today?
I am, Judge. I just wanted the record to reflect we did comply with victim rights notification. I do have a copy of the motion. I agree with the court's recollection. It was written on a plain piece of paper, and it was formatted like a motion typically would, with the caption and the heading of the motion. As you know, I'm not in the office today, but when I return on Monday, I'm certain I can put my hands on my copy and provide that to the court and Mr. Brooks if that is necessary.
All right. Thank you. I would appreciate that. All right. Anything else from you, sir?
No,
my apologies for
Yeah,
misplacing the
I was
form.
kind of shocked. I was just like, what's going on?
That's okay. I wanted to try to address an issue that you raised, but as you can
I
see,
would have hoped to have been prepared because when they said you have court, I'm like, I have nothing. Like, I'm just going in there with nothing.
now you know what it's about. We'll make sure we get some documentation to you, and once we locate that, we'll have it scheduled, and I'll have my clerks contact the receiving institution to find out the best timing for all of that, and to make sure that whatever paperwork the court sends to you, you actually receive. All right.